Hi! Welcome to our segment. Whether you're a law student, a legal professional, or just curious about your rights, this video will provide a comprehensive overview of the law of search and seizure. In the Philippines, Article 3, Section 2 of the 1987 Constitution provides protection against unreasonable searches and seizures by the government. But what does it exactly mean in practice? Thus, at this point, we'll explore the key principles of search and seizure law, including the requirements for warrants, the definition of probable cause, and the limitations upon the power of the state.
Article 3, Section 2 of the Constitution states that the right of the people to be secure in their persons, houses, papers, effects against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable. No search warrant or warrant of arrest shall issue except upon probable cause to be determined personally by judge, after examination under oath or affirmation by the complainant and the witness he may produce, and particularly describing the place to be searched and the persons or things to be seized.
As laid down in the case of Mancado versus People's Court, the rights against unreasonable search and seizures are available to all persons, including aliens, whether accused of a crime or not. In artificial persons like corporations, they are also entitled to guarantee, but as a rule, their premises may not be searched, nor may their papers and effects seized except by a virtue of a valid warrant. The rights against unreasonable search and seizures is personal and may be invoked only by a person who is entitled to it. Therefore, one who is not the owner or lessee of the premises searched, or who is not an officer of a corporation whose papers are seized, cannot challenge the validity of the search and the seizure.
With that said, what are the requisites of a valid warrant? As laid down in Calleja versus Executive Secretary with GR number 252578 dated December 7, 2021, the constitutional requirements of a valid search warrant or warrant of arrest are the following. 1. It must be upon a probable cause. 2. The probable cause must be determined personally by the judge. 3rd, the determination must be made after examination under the oath of affirmation of the complaint and the witness he may produce. And it must be particularly describe the place to be searched and the persons or things to be seized.
Now let us discuss what is existence of probable cause. Defining probable cause based on jurisprudence, it is the knowledge of facts, actual or apparent, strong enough to justify a reasonable man in the belief that he has lawful grounds for prosecuting defendant in the manner complained of, the concurrence of facts and circumstances reasonably warranting the belief. Probable cause implies probability of guilt and requires more than bare suspicion, but less than evidence which would justify a conviction. A finding of probable cause merely binds over the subject to stand trial. It is not a pronouncement of guilt.
Second requisite of a valid warrant is the determination of probable cause. The determination of probable cause is to be made personally by the judge. Under the Rule 112, Section 2 of the Rules of the Court, providing that a judge may issue a warrant of arrest only if he is satisfied from the investigation. To add, satisfying himself from the existence of probable cause from the issuance of warrant of arrest, the judge is not required to personally examine the complainant and his witness.
The third requisite of a valid warrant is the examination of the applicant. According to Rule 126, Section 4 of the Rules of the Court, the judge, before issuing the search warrant, must personally examine in the form of the searching questions and answers in writing and under oath the complainant and any witnesses he may produce on facts personally known to them and attach to the record their sworn statements together with any affidavits submitted.
The fourth and last requisite of a valid warrant is the particularity of description. The Constitution requires that the place to be searched or the persons or things to be seized be described with such particularity as to enable the person serving the warrant to identify them. Failure of this requirement may result in erroneous, or worse, arbitrary enforcement of the warrant. A search warrant issued must particularly describe the place to be searched and persons or things to be seized in order for it to be valid. Otherwise, it is considered as a general warrant. If the warrant is issued without a name or with the name in blank such that it can be enforced against any person, it is unquestionably void. A search warrant need not identify with particularly the person against whom it is directed. It suffices that the place to be searched and things to be seized and described.
Upon the effect of a valid warrant, what are the properties subject to seizure? Under Rule 1 to 6, Section 2 of the Rules of the Court, the following are subject to search and seizure. First, property subject of the offense. Second, property stolen or embezzled or other proceeds or fruits of the offense. And third, property used or intended to be used as the means of committing an offense. Where the search and seizures are made only for the purpose of obtaining evidence to be used against accused, the warrant is unlawful as it would violate the constitutional right against self-incrimination. Should there be no ensuing criminal prosecution in which personal property seized is used as an evidence, it's returned to the persons from whom it was taken or to the person who is entitled to its possession, but a matter of course, except it is contraband or illegal.
Articles illegally seized are not admissible as evidence. The rule has been constitutionally affirmed in Article 3, Section 3, Paragraph 2, which provides that such evidence shall not be inadmissible for any purpose in any proceeding. Such evidence is the fruit of the poisonous tree. As declared in the case of People v. Tuazon, when an appellant failed to timely object to the admissibility of the evidence against him on the ground that the same is obtained through a warrantless search, his failure amounts to a waiver of the objection on the legality of the search and admissibility of the evidence obtained by the police.
As mentioned, searches and seizures may be made with or without a warrant. Here are some of the instances where a warrantless search and seizure is valid. Number 1. As an incident to a lawful arrest. Number 2. Searches of vessels and aircraft for violation of immigration, customs, and drug laws. Number 3. Searches of moving vehicles. Number 4. Searches of automobiles or borders or constructed borders. Number 5. Where the prohibited articles are in plain view. Number 6. Searches of buildings and premises to enforce fire, sanitary, and building regulations. Number 7. Stop and frisk operations or the so-called Terry search. Number 8. Customs searches. Number 9. Searches conducted under exigent and emergency circumstances. Number 10. Searches and seizures at military checkpoints. And number 11. Searches based on tipped information in bypass operations for cases involving drugs in transit.
In the case of People versus Layla Johnson with GR number 138881, accused appellant Layla Reyes Johnson arrived in the Philippines to visit her son's family. When she was due to fly back to United States, Ramirez frisked John, a departing passenger bound for the United States. She felt something hard on the latter's abdominal area upon inquiry. Johnson explained she needed to wear 2 pants girdles as she had just undergone an operation. Unsatisfied with the explanation, Ramirez reported the matter to his superior Embile and was directed to take the accused to the restroom. The latter then brought out 3 plastic packs and they were later found to be shabu. Embile took the accused and the plastic packs to the arrival area of Naiya, where her passport and ticket were taken and her luggage opened. Pictures were also taken and her personal belongings was itemized. The trial court found Johnson guilty of violation of Section 16 RA 6425 or Dangerous Drugs Acts as amended by RA 7659. On appeal, the accused contends that she was arrested and detained in gross violation of her constitutional rights. She argues that the shabu confiscated from her is inadmissible as she was forced to affix her signature on the plastic bags without the assistance of counsel and without having been informed of her constitutional rights. The issue here is the constitutional right of the accused against warrantless search and seizures is not violated. The answer is no. The constitutional right of accused against warrantless search and seizures is not violated. This case involves an arrest in flagrante delicto pursuant to a valid search made at her person. The accused was validly arrested without a warrant pursuant to Section 5, Rule 113 of 1985 Rules of Criminal Procedure. Such searches are implicit in airport security procedures and are reasonable considering the gravity of the safety interest involved. Thus, the shabu seized from Johnson during the routine frisk was against legitimately pursuant to airport security procedures. Travelers are also notified that they are subject to search and any prohibited materials of substances would be subject to seizure.
In the case of People versus Kubkubin with GR number 136267 dated June 10, 2001, at about 3:30 o'clock in the morning of August 26, 1997, Sergeant Rogel, a desk officer of Cavite City Police Station, received a phone call that a person had been shot near the cemetery along Julian Felipe Boulevard. For this reason, a police team responded to the call and found Henry Piamontes lumped dead on his tricycle, which was parked on the road. A tricycle driver told them Fidel Kubkubin Jr., the accused appellant, and Henry Piamontes, the victim, were last seen together coming out of the Sting Cafe, about 1.5 kilometers away from the crime scene. 2 members of the policemen went to the cafe and talked to Daneth Garciliano, a food server. There, they found another tricycle driver and told them that Garciliano's description fitted a person known as June Dulce with the same description, leading them to where the accused appellant lived. Upon arriving, the policemen asked permission if they could enter the house. After entering, they found a bloodied shirt and 2 spent .38 caliber shells. Accused appellant was then asked to return to the cafe for identification. He was positively identified by the waitress to be the person with whom the victim drank with. The police then returned to his house and found a .38 Paltic pistol. The issues of the case, whether or not there was a valid search and seizure. The ruling of the court, no, there was no valid search and seizures. The accused appellant contends that neither he or his son gave permission to the arresting police officers. The right against unreasonable searches and seizures is a personal right that may be waived expressly or impliedly, but a waiver by implication cannot be presumed. There must be a persuasive evidence of an actual intention to relinquish the said right.
Thank you for joining us in this video on the law of search and seizure. We hope that you may now have a better understanding of your rights and the principles that guide law enforcement when conducting searches and seizures. If you found this video helpful, please like, comment, and subscribe for more educational content on the law.